I'm recording now to the cloud. Great. So you would take us, my name's Alan Montague. I'm with the NorCal SBDC and welcome to this Zoom webinar. You may have been on lots of Zoom meetings, but this is a webinar. It's a little bit different. So Louise, take us forward. We're going to talk about some of the ways you can communicate with us. So if you have questions, so first way is to raise your hand, and that is that button in the middle. If you do that, I will reach out to you in the background using chat and just check whether it's a technical issue you've got and communicate with you that way. And then once you pressed it, you can press it again and the hand goes away. To the right of that is a Q&A box, and that's how you're going to be able to put questions in for our panelists today. So if you click on that, a little panel pops up where you can put your question in. So the best way to do it is have a look at those questions. Depending on the settings, sometimes you can upvote other people's questions if there's one that's really close to yours as well. To the left of that is a chat. Chat should only be used if you need to contact me for technical support. If you click on the chat box, you'll see that it's there. And there's an option to the bottom of that says whether you can share this with all panelists and attendees or just with the panelists. Louise, if you could just show that. So what I would suggest, if you're responding to me, just click on all panelists and that will just be between you and me. Other than that, have a great time, and I'll be in the background doing stuff without being seen. I'm going to hand you over to Anne.
Thanks, everyone. Thank you for joining us today. I am really excited for the lineup of fantastic speakers that Louise has helped us secure, and so grateful for all of your time. I know it's valuable and you've got a lot of stuff going on right now. So our clients and SBDC participants today are really appreciative of that. I am the Associate Director for the NorCal SBDC Network, focused on programming, and the type of work that we do is these no-cost or low-cost workshops and one-on-one trainings that are funded by the U.S. Small Business Administration, as well as the State of California's Governor's Office of Business and Economic Development. We're incredibly grateful for that resource and that funding, because that's how we put together programs like this today. The work that we do, one-on-one technical assistance or advising, is always available to folks in the NorCal territory. Our network stretches from the Oregon border to about an hour past Stockton, all the way over through Santa Cruz County. That's 36 counties of Northern California. So we have a lot of different types of advisors throughout the network. And if you want to find an SBDC advisor near you, you are welcome to go to the norcalsbdc.org website and click on locations and find the one nearest you on the map. So without further ado, I'd like to introduce our Restaurant Program Director, Louise Dawson. That is a part of the NorCal network. There are a whole bunch of SBDC programs that we have, and one of the things that had happened with the restaurant program was she had done a fantastic webinar helping restaurants understand lease negotiations, etc., a few weeks ago. I wanted to broaden that for the whole network that included retail and other commercial type businesses. So that's what you're participating in today. And Louise, if you can take it from there.
Sure. Thank you so much, Anne, and thanks to all of our panelists. My name's Louise Dawson, and I am the SBDC Restaurant Program Manager, where, as Anne stated, a division of the NorCal network. I'm a second generation restaurateur. My family had 8 restaurants, 2 wineries, and a brewery, and so I grew up in hospitality and had a couple of my own restaurants and a large catering company. And along the way, I started to get into consulting and training. I started with the SBDC in 2004 to do some advising. And along the way, around 2005, I realized that the #1 issue that I was dealing with my clients was them getting into these sticky leases that they couldn't get themselves out of. So I went and interned for a year and learned the business and ended up getting my license. And now I'm a partner with Vandermade Commercial along with Mike, who's here. And Mike, I'm going to hand it over to you. Please introduce yourself.
Well, I'm Michael Chidambaram, and I'm a commercial real estate broker with Vandermade Commercial Real Estate. Been working in all property types for the past 20 years. So from, anything from office to industrial to retail to food and beverage. But the bulk of my business is food and beverage as well as retail throughout the Bay Area, but specifically in San Francisco. So dealing with liquor licensing, entertainment permitting, conditional use permits, and all of the hurdles and regulations that go along with acquiring and dealing with food and beverage, tenancies or owning buildings pertaining to that are areas that I specialize in.
Great, thanks, Mike. Now I'm gonna have Steve Zimmerman, our broker guru extraordinaire, introduce himself. Thanks for joining us, Steve. Appreciate you being here.
Yeah, my pleasure. I started the restaurant business when I was 15 as a dishwasher in a family business. My father opened his first restaurant in 1947. And he wanted to indoctrinate me before I knew any better. So I started washing dishes when I was 15, part-time while going to high school, and then cooked and did all kinds of, jobs within cooking, house. And then after a couple college degrees, stint in the service, I came into the business as a manager trainee. And so I worked in the family business for about 20 years. We had a total of about 37 restaurants in our career. We were the largest independent restaurant chain in San Francisco for about 40 years. We had 12 restaurants in San Francisco. So my role was, I started dishwashing and eventually became the CEO. And so fortunately, that gave me an opportunity to have a broad base of responsibilities, from negotiating leases to hiring management people to negotiating union contracts to designing and finding new locations. So a whole myriad, which serves me well to what I do now, which is basically selling restaurants. I am currently a restaurant landlord, a hotel landlord. And so I understand the landlord side pretty well. I started Restaurant Realty in '96. We have completed over 1,200 transactions, and we have representation throughout the state. We do deals from the San Diego border to the Oregon border, border. And we focus on restaurants, bars, clubs, and related commercial buildings. And so it'd be a pleasure to participate today. Thank you for including me.
Thanks for coming, Steve. And the reason I wanted Steve's perspective is because he covers all of California. Many brokers are just very geographical, and you kind of do a lot of mixed use stuff. And so I thought having that perspective of maybe things that are going on in rural areas as well as urban areas would be important for our discussion today. So again, thanks for joining us, Steve. We appreciate it. And now I am going to pass it to Roberta Economidis.
Thank you, Louise. My name is Roberta Economidis, and I'm an attorney at Judicial and Economidis. We are a small boutique law firm in San Francisco that does specialize in the hospitality industry. We have formed the firm over 15 years ago, but my business partner, Dr. Jopless, has been working with retail and restaurants for over 25 years. Hopefully you won't see the recording of me saying that. I know that there have been some questions about this being a restaurant focus, but I do think that everything we're going to discuss today is going to apply to other small businesses as well. So I look forward to being on the panel with everyone.
Great, thank you. Thanks for joining us, Roberta. So again, I just want to talk really quickly about the SBDC restaurant program. It's a specific program within NorCal. We have a wide array of advisors. We speak multiple languages. There's hospitality slants, a lot of food, artisan, retail businesses too that we deal with. So just had to plug that. So what we're going to be going over today is the three parts, really: the legal and economic landscape, what's going on right now. There's a lot shifting legally in the landscape with the pandemic. We're going to touch on force majeure and frustration of purpose, which are two legal mechanisms that people are talking about right now to maybe think about exiting their leases. And we're going to give you a little clarity around that. We're also going to talk about a case study. And then we're going to talk a little bit about the eviction moratoria in San Francisco, and I'm going to give you resources for all of the other counties. And Roberta's going to talk a little bit about the California Judicial Council, which is going to give you some great information on additional kind of, leverage with your leasing. And then we're going to talk about landlord and tenant perspective. So who has the leverage right now? What are the considerations between landlord and lender, tenant negotiation ideas, lease restructuring, and exit strategies. But we want to end on a positive note. So we're all going to chime in a little bit about future opportunities. So by the end of this meeting, you'll have a greater understanding of COVID era lease restructure strategies. So from the legal and economic landscape, this economic downturn is driven by conditions that nobody has experienced before, not in our lifetimes. And unlike the Great Recession, which triggered a financial collapse, we're actually experiencing a global economic shutdown. And the key here is that we have, and this is how it pertains to your leases, restrictive government declarations that have severely disrupted many businesses. So this is going to have an impact on real estate for years to come. And one area that really requires attention right now is the landlord and tenant relationship. The stay-at-home orders and the essential businesses have altered the legal real estate landscape. And from a commercial tenant's perspective, these orders may provide a legal basis for temporarily ceasing operations, as most leases expressly require tenants to comply with all applicable laws and government regulations. So this is usually found under the permitted use clause or, continuous operation provisions in your leases. So that, brings us to the question. We have a lot of clients asking, well, what's force majeure? And is that a clause that I can use where I don't have to pay rent? So every attorney you ask will give you a different answer on this. And so I just want to preface it by saying force majeure right now is very murky water. It's a provision with the right to cease or suspend occupancy during a governmentally declared disaster or emergency. Very few of our leases are going to include the verbiage that addresses a pandemic or a stay-at-home order. So if your lease does, then great, you have grounds. But again, it's a really hot topic right now. And if your lease doesn't contain that language, then there's some question marks around that. It really requires a deep dive if you're going to go this route, or you want more information with your attorney, because it's going to be very, very specific to your lease. And your current situation. It's a provision, again, in most commercial leases that provide relief and potentially changes your obligations in the event of a natural disaster, war, terrorism, labor strikes, and again, governmental orders. But the provisions aren't boilerplate. But many of the leases will, depending on the language, will provide for extensions of timeframes, automatic extensions, and an excuse for temporary non-performance. So again, I think I'm gonna just pass it over at this point to Roberta. Do you want to weigh in? I feel like this is a good time for you to come and talk to us about your thoughts on this.
So this is an extremely complicated issue, and it's one that I've had a lot of discussions with other attorneys. Force majeure is commonly known as an act of God, but really it's an event that nobody could anticipate. And there's a lot of common law around force majeure. However, because people didn't want to have to look to common law, they put force majeure clauses in their leases. Those clauses dictates what happens when a force majeure occurs. And fortunately, the leases or many provisions in the lease will say that you no longer have to obviously stay open for the hours that perhaps you're required. You don't have to conduct the maintenance that you have to are otherwise required to under the lease. What we're finding as problematic is that many force majeure clauses say your obligations are lifted except the requirement to pay rent or pay additional rent. And that is really what has become problematic in this. And I know that everybody on this panel has participated in negotiating in leases. And, you know, we look back to those negotiations and landlords will say, well, of course you're going to pay rent because you have business interruption insurance and that's going to cover it. And that was really something that many people anticipated. And unfortunately, we're finding that in this pandemic, like so many things with this pandemic, that's not the case. So the clause generally in many leases does not provide for a tenant to not pay rent. And Luis talked about whether or not a pandemic was listed in your force majeure clause and whether or not that applies. And that is really a state-specific question. So a lot of times I will get an email from a client or a call from a client and say, Roberta, I heard that this happened, or have you heard about this case? And I'll say, well, that case is in New York. And for example, in New York, if a pandemic is not listed in a force majeure clause, New York has a very narrow interpretation of these clauses, and the force majeure clause will probably not apply in New York if a pandemic is specifically not listed. At least this is the conventional legal wisdom. California has a broader application. So even if it's not listed, your force majeure clause still may apply in a pandemic. Furthermore, many of these clauses have catch-all phrases that will include things, you know, it will say, and all other acts of God. So that's a little bit of an overview of a force majeure clause. It's very important that you review them and that you look closely as to what your obligations are and are not under that clause. Now, that's not going to be the end of the conversation with respect to legally what may happen, but I think it's a very good starting point.
Great, thank you, Roberta. And I think another thing to mention is that, you know, because we haven't had a pandemic before, we don't have kind of a lot of case study out there. You know, and we were, you know, I've been going over leases with some of my clients, and there's language specifically in the force majeure clause that will say, you know, failure of performance, as you had stated, you know, you're still not off the hook for paying the lease. But there has been some cases way back, like prohibition area cases in California, that found a lease was rendered inoperative by prohibition. And so therefore the extra language that was added to the end of that, your catch-all phrases, did not apply in this case. So do you want to add to that, Roberta?
I'm happy to. So many people are now looking to impracticability and or frustration of purpose as an alternative to force majeure. And I cannot stress enough that there is zero case law out there that anyone can find that is on point with what we're experiencing today. So the interpretation is very much going to be up in the air with respect to what courts will do. It may differ from state to state. So I want to manage expectations when we have the conversation surrounding frustration of purpose or impracticability. But the general idea is that the reason you entered into this lease was for a very specific purpose, and now through no fault of your own, you cannot, the lease no longer serves that purpose, and you can no longer run your business accordingly. The example that Louise gave was the pre-prohibition case, and actually there were numerous cases where people leased a saloon. People said, I'm opening up a bar, and then prohibition came along, and court said, well, these people cannot open up a bar. They can't have a bar anymore. Therefore, the purpose of the lease is frustrated. Interestingly, there are legal theories out there, and there are conversations out there, and there may even be cases out there that we all haven't done a deep dive into on a national level for guidance, that would say if you entered into, at that time for pre-prohibition, a lease for a saloon and a smoke shop or a smoking establishment, that the courts would have said, well, you could still have that cigar bar portion of it. So therefore, there's not frustration of purpose. And so the reason I raise that is because the saloon example is, in some respects, a perfect one. And what we are going to hear from landlords in response to a frustration of purpose argument is going to be, yes, but you could still have a restaurant. Yes, but you could still have retail. You could do to go. You could do online ordering. Therefore, you can still have the business that you contracted for. And in a frustration of purpose or impracticability argument, the fact that it causes you such a reduction in your income or in what you make as a business is not in and of itself going to assist you in those arguments.
Great points, Roberta. Thank you. Can you give us an update right now, like an overview? A lot of our attendees may or may not have heard about what's going on with SB 939. Can you kind of talk us through the original intent of that legislation and where we're at now with the current updates?
Sure. So because there's such a question around frustration of purpose and impracticability, one of the things that Scott Wiener, our state senator, Scott Wiener here in San Francisco, and Lena Gonzalez in Long Beach wanted to do was to provide clarification around what would happen in the event that people lost 40% more of their income due to COVID-19. And effectively, what the bill originally set out to do was two parts. One of the parts would be if you met financial metrics as a restaurant only, or a performance venue or a bar, recognizing that this industry had been hit particularly hard in the COVID-19 crisis, that you would have the opportunity to attempt to negotiate with your landlord to renegotiate the terms, the economic terms of your lease. And if you were unable to, that you would be able to effectively terminate your lease with very mitigated damages. The original intention was 3 months worth of rent. The real estate organizations, as anticipated, have come out in full force against this provision, and they meaning Scott Wiener's office and Lena Gonzalez's office, are currently working with them and working also with people in retail, nonprofit, and hospitality to try and find some common ground and make some amendments to that particular provision of SB 939. There's another provision of SB 939 which would effectively stop any evictions, put a moratorium on evictions. Originally, again, it was through the state of emergency in California, and now that may shift to the shelter in place, but it would put a moratorium on evictions for non-payment of rent during COVID-19 and allow for a 12-month payback period post shelter in place or state of emergency. Again, These bills, as bills always are currently being negotiated and discussed, and we're all trying to find common ground to try and find something that will work. The idea is to protect small businesses and nonprofits from evictions, and also to prevent lawsuits. If we don't have some safeguard in place, we are going to see a number of lawsuits with respect to leases and a number of bankruptcies. And that's something that we don't want to see, and I think is bad public policy for California. So hopefully SB 939 is going to make it through the Appropriations Committee. It passed Judicial Council a couple of weeks ago, and I'm sure that many of the viewers here have opinions about SB 939, and I encourage you to reach out to Senators Wiener and Gonzalez and your own state senators to discuss your views on this matter, because it's very important that your voices be heard.
Great, thank you. So when Governor Newsom's order first came out, there was a little bit of an oversight. It was mostly covered residential and not a lot of commercial. And so, you know, our retailers were kind of left wondering what was going on. So a lot of the cities picked up the ball on this, and some of them adopted their own eviction moratoriums in their particular areas. And so what it is there's a temporary moratorium on evictions for tenants who are unable to pay rent due to COVID-19. It does apply to commercial leases. Grounds for non-payment include loss of income due to business closure or reduced hours or customer demand caused by COVID. For example, in San Francisco, it only applies to commercial tenants with gross receipts of 25 million or less. It provides eligible tenants up to 6 months following the expiration of the emergency period for paying back. But nothing in the order relieves the tenant of their actual obligations to pay that rent back. So I've put a link here, and you'll all be getting a copy of this with the follow-up to see if that you qualify for the San Francisco moratorium. But there's a great link here that gives you all of the cities and all of the other moratoriums. So you can click on it and check and see what applies to you. And another slide here, I just quickly want to have Roberta talk about. She sent some great information over. And this is sort of a follow-up to kind of bridge the gap. I think the California Judicial Council saw that Newsom left out commercial, and then all of these cities were putting in their own moratoriums, and it became very confusing. So they did a blanket enactment for this. Do you want to talk about this briefly, Roberta?
I'm happy to. The California Judicial Council wanted some uniformity within the state, and so currently the Judicial Council has ordered that for any unlawful detainer action, it will not issue a summons for that unlawful detainer action for 90 days past the California state of emergency. Now, the state of emergency could go through all the way through 2021. And just so that everybody is clear, all of us attorneys are anticipating that the Judicial Council is going to dial that back and will effectively lower that possibly to shelter in place or some other metric. However, as of today, while a landlord may be able to file for an unlawful detainer action for an eviction, none of the California courts are issuing a summons and that is particularly what would bring a tenant to court under that. So effectively, evictions are stayed in California.
Great, thanks. I've lost my screen here for some reason. I apologize for this. Alan, do you think you can help me here? So I went to answer a question for you and it just disappeared on me. So do you want to maybe run the screen? Do you want to run the presentation? Because I can't seem to get back in.
Alan, you're muted.
Of course I am. That would make perfect sense to be muted under the circumstances. Let me just share that slide.
Let me stop the share.
While you're doing that, Roberta, so somebody's asking, Matthew's asking specifically, could anybody talk about the likelihood that 939 will pass, and when that might happen? Where is it at?
If it passes, it's going to pass in, I believe, September, and it was put forth as an urgent bill. There's something in the legislature called an urgency clause, and effectively that means it needs to be fast tracked because they didn't want to wait until 2021 for this to be passed, and it will take a 2/3 vote of our legislature. So if it's passed, Governor Newsom doesn't have to sign it, and it will go into effect. But a 2/3 vote of the legislature is going to be very, very difficult to attain. It's just a reality, and I think we in Bay Area Hospitality, who's been very active in the bill, knew that it would be a high hurdle, but nevertheless, you know, we're proceeding.
Great, thank you. Do we have any other questions right now, Anne, that we should maybe cover?
Yeah, so are there any types of businesses that are excluded from SB 939? Could you talk about that?
So again, all of these things are still in flux because as these bills go to committees and legislators will say, I will not vote for this unless you have X in there or Y. So the moratorium on eviction, that applies to all small businesses and nonprofits in the state of California. And originally the bill said that a small business was under 500. We kept it broad. We went with the PPP standard, if you will. It looks like that will be dialed back to 250 employees. That portion of the bill will apply to everyone who's under a small business, primarily in California, 250 or less employees. The provision that would allow for a termination or potentially a cap on damages, which is another route that we're exploring right now, would only apply to the hospitality sector.
Can cities or counties create their own regulations with higher standards than the state? Point being, like, could cities increase protections for tenants? For example, extend the payback period of COVID closure rents to 24 months instead of 12? Or are those things in discussion right now? Are you aware?
I can't speak for all localities. I do think that local governments have the ability to do some of the things that you just brought up. In San Francisco, I think it's been extremely helpful that there is a mechanism for payback. And I briefly saw a question come up in the Q&A, and I know a lot of people feel that the deferment is not enough, and I agree with them. I keep saying deferment today cannot become an insurmountable debt later, and that is what our legislators need to understand, whether it's on a state level or local level. Ideally, it would be on a state level because it would be uniform and we wouldn't have conflicting state and local law. So for those of you who feel frustrated about this, I really encourage you to reach out to the state senators and let them know what your opinions are. It's important. It's important that every small business use their voice right now.
I know we are going to be talking about negotiating leases, correct, Louise?
Yeah, I think we'll move forward. Can you advance us, Alan?
Yep.
We're going to get through some of these questions during the contents of the slide, including strategies. So,
okay, next slide.
Yes, please. This is Mike's going to take it from here.
Yes. Can everyone hear me okay? I'm using a wireless headset. Yeah. Great. Okay. So I think before we get going, I just wanted to say, I know how difficult this is for everybody. I'm talking to tenants and clients, you know, and landlords, you know, every day. And they're all at kind of wit's end with regard to where things are going to go. There's tons of uncertainty. Nobody, you know, really wants to throw in the well, not everybody, but a lot of people don't want to give too much because it may set a precedent, may you know, bite them later. So if you're feeling just like overwhelmed by this, you're not alone. So hopefully after we go through this, you'll have some good strategies. So leverage, it's shifted. You know, every tenant's in the same boat here. And so, you know, there's a lot of, there's like a tsunami of potential defaults and, you know, court actions, et cetera. So this is leaning the leverage toward tenant, we feel. Now, even though the landlord can threaten eviction, as we talked about, there's moratoriums in place. And even once moratoriums are lifted, the amount of backlog, I've talked to attorneys that said, you know what, you're not even going to get a case heard for a year or more. So that's a further disincentive for landlords to pursue action for, say, perhaps collecting or trying to collect on a personal guarantee, or thinking twice perhaps before they embark on unlawful detainer action where they're not going to get relief for a long, long time. So number 3, lawsuits, not the best options, given the changes that are coming, you know, the uncertainty, and the just difficulty in getting your case heard. Current trends are showing mortgage forbearance. So as lenders provide options to landlords, that further disincentivizes them from just going after the tenant if they can get relief from their lenders. Next slide. Vacancy costs to landlords. So in entering into a negotiation, you know, to discuss. Oh, you know what? I think we've missed a slide. Yeah, there we go. So what are the trends that we're seeing right now? Roberta, Steve, if you've seeing anything different. Landlords giving a few months of free rent, you know, kind of during shutdown period when businesses have been closed. They're conceding to either, you know, providing free rent or significant decrease in rent. Not a deferment where you have to pay it back later, but actually providing an abatement, lowering the obligation of the tenant during those months. Then, in addition, we're seeing short-term rent reductions of 30 to 40%. What's the short term? You know, could be an additional 6 months, 12 months, some amount after the initial shelter in place or non-operation period. And then in terms of payback negotiations, even if landlords are saying, hey, don't pay rent now, and by the way, we'll reduce it here, you just pay half rent for 6 months. Many are not wanting to actually you know, put this into the lease and you know, make a decision right now as to what happens with that amount of rent not paid, you know, and they're trying to keep their options open, which is understandable, although it can be a real difficulty for a tenant, as Roberta said, you know, hey, it's great we're getting a reduction in rent now, but if it means in 12 months we're going to be paying double what we were before pre-pandemic, that's not a successful option either for a tenant. So
hey,
next
Mike,
slide.
I'm curious on what Steve's seeing right now because he does such a volume of clients. I'm wondering what he's seeing on the leasing side right now.
Yeah.
I'm seeing a lot of what Michael has just discussed, but in addition to that, I'm seeing there is some deferment going on, but as stated, deferment is it's a balloon payment that it's going to make it untenable for many people to.
I think we've just lost Steve.
I think Steve's just frozen up on
frozen.
us.
I'll speak a little bit more to that. I created a rent schedule for a client last night.
New deals. Go ahead, Michael. Sorry.
No, why don't you continue with your thought?
All right, fine. So I'm basically counseling clients to, you know, forget deferment, you know, a reduction, which just a quasi abatement, you know, a total abatement for a period of time. But try to stay away from deferment. Although again, there are some tougher landlords that are saying, you know, no way am I going to give you any total relief. It's going to be, I give you a deferment. And that's the best I can do. So, but you know, it appears, because, you know, I do have a geographic perspective from doing the whole state. Obviously, in rural areas, there's a lot more liberal landlords, you know, pre-COVID and COVID and post-COVID. That's just the nature of the chemistry of the landlords in those areas. And so they're a lot more amicable to, you know, abatements and, you know, through the shelter period and then some. You know, it's just sort of kept vague, you know, as Michael's indicated in some cases. So it's just a combination of things. But, you know, generally speaking, the buyer lessee is in the driver's seat. And because of the backup of the courts and realizing they're not going to be able to take any really meaningful legal action short term, they're generally willing to work with their tenants. And that's what I'm finding.
If I may, one of the things that I'm finding is, especially in the hospitality world, is that people are doing, if they are doing to go, and now perhaps even with retail being quasi opened, they are moving their rent to a percentage of gross revenues. I'm seeing anywhere between 5 and 10% of gross revenues in lieu of what your basic rent normally is, and or a combination of fixed rent plus revenues, and or a combination of triple nets plus percentage of gross revenues. So I think it's really important that you communicate with your landlord, that you try and keep the lines of communication open. It's really difficult depending on the relationship, but also it's a time to get creative and find out what your landlord's needs are and how the two of you can meet in the middle, so to speak, to get through this together. That's ideal, and unfortunately, that's not everybody's experience.
Great, Mike.
Okay, Alan, can you forward us to slide 34? I think it would be good to just go to this one first and then come back. Yes. So when considering, so as a tenant out there, and also a landlord trying to understand that tenant's situation, the way I see it is there's 3 time periods, you know, with what this pandemic has done is it's created 3 discrete realities or situations which are going to happen one after the other. The first, which we've been in, is this shelter in place where retailers had to close, bars had to close, nightclubs had to close, entertainment venues are closed, and restaurants are restricted to takeout only. That's been going on, since early March till, at least in San Francisco, I think has announced, actually June 15, we can have outdoor seating. And July 15, we're allowed to do distanced inside service. So this first section means right now, before they allow this inside seating, business is unable to operate in its current form. It's been takeout only. Sales have plunged, you know, down to 0% or perhaps, you know, 50% of pre-pandemic levels for many, many businesses. Now, quick serve businesses, there's some that are doing even better than before. The businesses are optimized for takeout. They're crushing it on the apps. They're doing, you know, takeout cocktails and things that they never could do. So there are some businesses that are actually okay in this, but the vast majority, I think, of retail and food and beverage businesses, you know, the sales have just taken a huge dive. Now, the target rent for this time period, I think, and as Steve pointed out, is no rent. You know, if you can't operate and you're making $0, you know, even with free rent, you're still burning through cash. You know, you may be paying people, you've got your utilities and insurance and other obligations. So that's your target, is no rent with no repayment obligation. Now, in the next time period, where in San Francisco, that begins this month with outdoor and next month with indoor, we're expecting, and it's in San Francisco anyway, it's based on a distancing calculation. And so every business is going to be a little bit different with regard to what that means in terms of their occupancy compared to where it was. So I'm estimating, and in talking to other tenants, 50% to 75% decrease. So if you had seating for 100, you're now limited to seating for 50. And you may be able to get some more outdoor tables or a parklet or something, but your chances are you're going to have a lot less seats, which is going to limit your operations and most likely your revenues. In addition, you're going to be suffering additional COVID-related costs. You're going to have to do barriers between tables in some cases, additional cleaning. You may have to do crowd control, like not have people lining up and have maybe a receptionist where you didn't in order to seat people. You may not allow people to just line up at the bar to order a drink. Now they have to wait. There's PPP for your staff and other considerations, which are going to levy additional operating costs on the business.
Hey, Mike, do you mean PPE? Do you mean the equipment?
PPE, yeah.
Okay.
Sorry about that.
It's because we were having that conversation on PPP right as we were typing it.
Yeah, right. Prepayment penalty. No, that's a wrong acronym. So yeah, the equipment that you're going to supply: masks, face shields, gloves, that's going to cost you additional money. Where are sales going to be? Can anybody guesstimate this? Everyone I talk to is just it's taking shots in the dark here. So, Steve, do you have clients that are able to forecast where their rents are going or where their revenues are going once they can get back to, serving indoors?
Well, before I comment on that, let me just piggyback off what you said in terms of a global picture as far as California is concerned. The California Restaurant Association is saying that 30% of all eating and drinking places in the state will not reopen after shelter is lifted. That there's 80,000 approximately eating and drinking places in California. So that means there are going to be a lot of fully equipped restaurants, bars that are going to be vacant, which obviously puts more emphasis on the buyer's leverage, or now buyer will become more of a lessee with the ability to possibly get into these spaces for no key money or little key money, and just having, good credit and some management skills. And I'm seeing in some cases, landlords are being receptive on some of these closed restaurants that don't plan to reopen, on dealing with prospective new lessees that have no restaurant experience, which has never been the case before, because the high risk factor, 50% in the first 3 years, 80% in the first 5 years go out of business in the independent non-restaurant arena. Landlords are very skeptical about taking unexperienced people, but they have basically good, like for example, I'm working on a deal in San Francisco. The buyer has basically a high-tech background, but he's had management experience and he has a decent financial situation. And that coupled with the seller giving him extensive training, the landlord is willing to work with this person. And he said, got no restaurant experience. Before pre-COVID, that would be a non-existent situation. So the reality is, again, to add the added leverage that the prospective lessees are going to have out there with all these, fully equipped places, and retail, as we know in general, was suffering before this COVID because of online sales, et cetera. So it really puts the lessee / buyer into the driver's seat. So specifically, what was the last thing, Michael, that you brought up?
Well, just where sales are, for not for a new restaurateur coming into a space, but for an existing restaurateur, once they're able to resume operations, what forecasts are they making? Are they forecasting 50% of sales because they have 50% of the seats? It seems to be a bit of a guess.
Yeah, my crystal ball is as good as your crystal ball. It's obviously if you have less capacity, 50% less capacity. Logistically, you think, okay, your volume's going to drop at least by 50%. And as it is with 100% capacity, most people have a hard time making money. So, and then if they can augment that 50% reduction with takeout and delivery, and by the way, the takeout and delivery is no panacea. The Golden Gate Restaurant Association did a survey of about 300 restaurants, and the final result was that 60% of the people and this was the people doing takeout and delivery during the shelter, 60% are not making money, 25% are breaking even, And so you got 15% of people doing takeout and delivery are making money. Unless you have a model specifically designed to do takeout and delivery, it's very hard to make money in that.
Yep.
Hey, Mike, what are you seeing with retailers? What are you seeing there? Are you seeing anything different in terms of percentages between restaurant and, say, clothing stores or other types of retail?
Yeah, I have not been investigating or speaking to retail clients with regard to what their operating restrictions are going to be. Depending on the store, I mean, we're seeing some stores open now, and they're, grocery stores are kind of holding some people back at times, but then I've gone into others that are packed. So it seems to be kind of across the board. I think restaurants specifically are, because they have a legal occupancy and a number of seats, they're going to be more regulated because it's easier to regulate. Now, whether or not there's going to be the occupancy police coming around and counting heads, who knows? But regardless, there's meant to be less people inside. So to answer the question on the final item, number 2, what is the rent target if you're talking to a landlord? Well, we don't know because you have no idea what kind of business you're going to be doing, what kind of sales volume you can possibly do with these restrictions in place. So my guidance is the target rent should be low, and there should be a percentage rent bonus. So as the sales climb, or perhaps we're all surprised and there's such a pent-up demand from people and they're willing to stand in line, and you can do 5 turns a night and everything works out great, then there should be a percentage rent, a percentage of growth that brings more revenue to the landlord as the tenant's business is doing better than expected. And so the final time period here is when we're past, when COVID is in the rearview mirror, operating restrictions have been lifted, we're back to, quote, normal. When does that occur? When do we get a vaccine that's created, that works, that's injected into enough people in this country? And presumably the world, because you can have somebody fly in from elsewhere that's infected. When is that? 12 months, 24 months? I'm leaning more toward 24 months before that actually happens. And what does that time period look like? My guess is the economy is going to be much worse than it was pre-COVID. We're going to have lower consumer spending, coupled with, in some cases, a fear of eating out or being in crowds. Now, the Marina District is having street parties in San Francisco. They're going, and it looks like New Orleans down there. The police are being called out, not for protest, but because of a drunken disorderly in the streets. So there could be in some areas like really great demand. But in other areas, people may be much more fearful, and it could lower your demand and sales volumes. For sure, there's bound to be less tourism, less business travel, less convention. So if your business is in a place that depends on those sources of customers, you're going to be impacted. Additionally, higher vacancy rates. We're already seeing this on the streets as for lease signs come up, as businesses close and spaces go back to landlords. With higher vacancy rates, typically you're getting less foot traffic. So, if you depend on a lot of foot traffic, say you're in a strip mall, and suddenly there's a lot of vacancy around you, that could negatively impact your business as well. Flip side of that is there may be less competition, so that may balance out. And in addition, we have the possibility of another COVID wave in the future and additional operating restrictions to come. So these are 3 discrete time periods with 3 different negative impacts or differing amounts of negative impacts to your business. And I think it's useful to think, when you're negotiating with a landlord, to think of the relief you need in each of these time periods. And we don't know necessarily exactly when the time period begins, but we know it's going to happen. And so if in the negotiations you can agree that during this time period of limited operation, you forget the old rent schedule, you're going to 50% rent with a percentage rent bonus on top of that, that may be a good way to protect yourself from lower from lower revenues, and also the landlord can protect themselves from, in the event that the revenues jump right back up during that period. And then post-COVID, where's the economy? Where's that rent schedule going to be? I think you just have to take a hard look at where you were before and see how things are going during the limited operation, and make a judgment call on that. Maybe you can keep the percentage rent kind of structure in place. Maybe it can start ratcheting back up to get closer to where it was before. But essentially, you could be building your business, assuming you were doing really poorly during limited operation, or your business just doesn't suit well for that type of restriction. Maybe you had so much, you've got a 30-seat restaurant and tiny amount of space, and now you're down to 5 tables or something, or less. It may not, you may not be able to really keep your existing business working the way it was, and consequently, when you're back to quote normal, when the restrictions get removed, you're building up your business from scratch again. And to build it up from scratch with what the rent was or would have been at that point, plus potentially paying back, as Roberta was cautioning against, having to pay back a bunch of, or maybe it was Steve, deferred rent, i.e., well, we deferred, $20,000 of rent. Now we're going to add it back into the lease going forward once this occupancy restriction gets lifted. Suddenly you're paying more than market rent from before, and your business is, likely not nearly as good as before. So these are the considerations for the 3 time periods that need to be thought through. And
Michael,
if there's any thoughts on that.
Well, I just had I'm wanting, because I know that we've promised people that we would talk about lease negotiations.
Yes, I was going to jump back to those other slides now.
Yeah, that would be great.
Yep. So if we can go to, we did the leverage, the trends. So landlord considerations is the next one, number 31.
Okay.
And so when starting your negotiation with a landlord, consider that they have all these costs. It's good to know that they have downside if you were to leave, because it should make you realize you've got a bit of leverage here. What are those costs to a landlord? So when a landlord gets a space back and is sitting on it empty, there's a loss of rent while it's vacant, obviously. There's potential cleanup, repairs, maintenance of the property, getting it ready for showing. There's property tax, insurance, utilities that now the landlord is going to be paying. There's the liability. In some cases there may be parking lots. There could be places where people, there could be break-ins. There could be, all sorts of things happen with vacant properties that are not good, and a landlord would be responsible for them. Then there's legal costs of drafting new leases once there's a tenant ready to lease the space. And then specific leasing costs associated with inducing a new tenant. You can bet there'll be a free rent period given to a new incoming tenant. There may be an improvement allowance if the tenant needs to make changes to the space with their concept. Rent concessions, i.e., the rent's probably not going to be at pre-COVID levels. So going forward, a landlord would need to be competitive, especially in light of having a lot of vacancies on the street, as well as brokerage fees. So there's significant costs here that a landlord has to bear in the event that a tenant hands him back the space or the lease is terminated.
Go to the next slide.
To the next slide. The landlord has lender, considerations. So if, most landlords will have mortgages on the property. Oftentimes, or in most cases, the lender has languages in the loan that reduces the flexibility of the landlord to change the lease terms. The lender agrees to loan in many cases because of the lease that's in place. So going and slashing the rent in half, violates the terms of the loan. And in most cases, landlord has to obtain lender consent. So they have their hands tied in some cases and in some ways. So that's another thing to consider.
Okay, next slide.
Okay, next slide. So while keeping those items in mind as a tenant, here are the talking points that a negotiation could start with. Tenant's investment in the property. So before you bring up the bad news of how you're doing and that you need a rent reduction, remind the landlord of the amount of money you invested in the property. Whether it's a retail business or a restaurant business, oftentimes the tenants have invested a lot of money in building out the space, improving infrastructure, and generally adding value to the landlord's building. And so to quantify that and make sure the landlord has that, remembers all that, or maybe they don't even know the extent to what was done and how much it cost, it's a good idea to bring that up and show, maybe show your a summary of costs that you've invested, as well as startup costs and losses in starting the business. The idea here is to show the landlord that you've got significant skin in the game as a tenant. It's not, most tenants didn't just walk in and pay a security deposit and open for business. There's significant investment in capital and time, resources. The next item is your financial trends prior to pandemic. So from when you opened, maybe your initial losses, to building up your business and cash flow up until March of this year, where things are gone, and showing some of maybe the cash flow if landlord's not aware of that, or just gross sales. And then you can contrast that with the losses that are currently being suffered. If you're one of those businesses that went from 100% sales to 0% sales overnight, you can show that by showing your bank statements, balance sheet, POS reports, evidence of lost sales and orders. I've got catering clients who just, every one of their orders for the year just instantly evaporated, millions of dollars of orders. So show the losses that you're being suffered. The next is demonstrating and illustrating that you have done whatever you possibly can as a tenant to mitigate your losses. By way of applying for the available disaster relief programs, looking for bank loans, changing your business concept. Maybe you didn't have takeout before. Maybe now you're doing a lot of, or trying to do a lot of sales of alcohol to go. I've got clients that are setting up bottle shops to do retail sales, or doing grocery kind of store concept. So whatever you're doing to, thinking outside the box to try to make up these for these losses in the event that extent it is possible, definitely talk about that. As well as talk about, reducing expenses. I'm sure, if you can't operate to the extent you were operating before, you're probably laying off a lot of staff. So reducing expenses wherever possible. This is evidence that you're doing whatever you can to be as profitable as you can. And next, talk about the mortgage, or ask about the landlord's mortgage situation, what their obligations are. Now, every landlord's different. It's a mom and pop landlord who invested in a building and this is their retirement and they're living off that rent check every month is different than a landlord whose business is commercial real estate and they have, 50 buildings, and they're, some buildings may be doing great, others may not be. So trying to get a sense of what the lowest base rent possible that they could entertain for some period of time. And we have a note here for Roberta to talk about Prop 13 and capping property taxes.
Thank you, Mike. One of the things that I think you may want to consider in terms of negotiating with your landlord is potentially negotiating a cap on the real estate property taxes that you pay if in fact you have a lease that requires you to pay the landlord's property taxes. There are a couple of things to consider. One, there is a measure on the ballot in California in November to repeal Prop 13 for commercial, which I think would have an enormous impact on retail across the state. It was a concern that we had pre-COVID-19, and it was something that we thought would be defeated. However, I am concerned about it given the fact that we now have a $54 trillion deficit in California. So there has been a long time movement to repeal Prop 13 for California, and I don't think it's out of the realm that will gain traction given what's happened. The other thing to consider is property taxes are based on the purchase price of the building. I spoke with a lender the other day, and they do anticipate that there's going to be a lot of movement with respect to foreclosures and sales of property. So if the mom and pop landlord that bought that place 30 years ago has property taxes in the lease that you're paying, and they end up selling that business, or sorry, selling that property, your property taxes could increase proportionately to what that sale price is. And so it may not be something that's on people's radar, and it may not be the number one priority when you're renegotiating your lease, but I encourage you to keep that in the back of your mind, because you need to set yourself up for success. And it's not just with respect to rent, but it's with all of your other economic costs. The other thing to consider, and I know this is not on the slide, but I do have clients who have been saying to landlords, look, let's negotiate for this amount of rent and this amount of money. And in the overall negotiation, they are also putting in a termination clause whereby they're saying, if I try to come back and I cannot come back and I fall below X amount for 3 consecutive months, I will terminate the lease and I will owe you.
Alan, I'm sorry. I'm sorry to interrupt you, but can you advance the slide forward, because we're kind of jumping ahead a little bit. We've got an exit strategy section, so I just kind of want to make sure that we address that then.
No problem.
No, Alan, you need to go in order.
Good point. So yeah, we should be on the tenant lease restructure strategies. It's just to cap off what Roberta was saying. Yeah, anytime you're negotiating a lease, most leases provide, if you have a triple net lease and you're paying the property, your percentage of the property tax, if that landlord's had that building for 1 million years and, it's a $10 million building and the assessed value is, $900,000 and they sell that building, then that building's going up 10x in value. Those property taxes are going up 10x. So even in a gross lease, most gross leases account for an increase in property tax over what was included. So the same thing can happen. You're at risk of a big added cost. So it's good to keep in mind whenever entering into lease negotiation. And it's good to see what the current tax value of the building is. And that can be, it's a public record. So it's something you can look into or talk to a real estate agent about, or property, or a title company.
And hey, Mike, I just want to let you know, we've got 20 minutes left and 30 questions. So we really kind of need to power through the rest of the slides.
Okay, so now we're into restructuring, lease negotiation strategies. So some small asks of the landlord would be taking your security deposit, applying it to rent. And by the way, these are just ideas of things that can be asked for. It's not an exhaustive list of what can be done here, but it should give you some ideas of things that can be done. So smaller ask, apply your security deposit to rent so that you don't have to pay it, collect CAMs, common area maintenance charges, but defer base rent. So you're paying the landlord's operating expenses, but not the rent. Suspend late fees and interest. On the larger size, abate the shelter in place rent. So this time you're closed or can't really operate. Abating obviously means you're not obligated to pay it. You don't have to repay it. So get some abatement for now or a set period of time. Reduce or defer the rent now in exchange for signing a more favorable lease to landlord. such as an extension. Jermaine, I don't think is with us. I don't know what his example was there.
Yeah, no, what he did, and I'm just answering the question on that. Terry Nevin said, it seems your panel is not taken into account PPP grants that enable small businesses to pay rent during the duration of the PPP. So that's 8 weeks. So yes, and a lot of people are using that. 2 of our advisors use that strategy, Terry. They went to the landlord and they said, look, we've received our PPP. As of now, we can spend 25% of this on our rent. So we'd like to give you 2 months of full paid rent right now. And then what they did was Adriana negotiated a 30%, I believe, decrease in her rent through December. Jermaine used it to actually start a brand new lease with like great terms for his location. So yeah, that PPP can also be a leverage. So I just kind of wanted to throw that out there.
If I could just jump in on that, yeah, as you probably know, they just amended the PPP requirement. So it's a 24 weeks now, and it's a 60-40 split between payroll,
Yeah,
utilities, insurance, and rent, etc.
yeah, we have so many trainings on the PPPs that there'll be updates through the SBDC all coming up Friday and next week. So thank you for mentioning that, Steve. And so, you know, you guys can tune into those updates because there have been changes, or we're close to a change. And so you can get more up-to-date information by accessing the calendar on the NorCal SBDC website.
Could we go to some of the other lease negotiation questions before moving forward, or is this, do we need to?
I just think that how much can you just?
I think we should just burn through these few slides because it'll cover a lot of this stuff, and then we could jump into questions.
Yeah, that's what I'm
So
saying.
just to cap off these other asks of landlords, and by the way, if you're receiving a relief from government agencies, loans, whatnot, obviously that's part of the calculus that you would work with in speaking to a landlord. We'll keep that in mind as well. Another item is deferring rent now, adding it to the back of the lease. That may be detrimental, especially if you're looking at a bigger rent obligation in the future while you're trying to build your business. Reducing rent to percentage we've talked about, so it kind of shares the risk between tenant and landlord based on the sales that the business can do. Also deferring rent for a set period to be repaid through a promissory note or amortized over the remaining lease term. So not necessarily a balloon payment, but spreading out that repayment. Again, it can lead to you paying more rent than you can bear later and putting your business in peril. Eliminating or limiting personal guarantees. Anything if you're going to have to walk away and you have a personal guarantee in place, you're liable for the damages that the landlord faces. So, if you can eliminate or limit the guarantee amount or eliminate the guarantee, that would obviously be beneficial if you can get it as a tenant. So landlord structure, this is from the perspective of a landlord, tying rent relief to the end of the shelter-in-place orders, but avoiding, not putting your tenant out of business. So avoiding insolvency with a lower base rent plus percentage rent with monthly access to P&Ls, bank statements, accountants, for verification of the tenant's sales. Obtaining a personal guarantee. So this is the flip side. A landlord that doesn't have a personal guarantee may want to or be willing to grant rent concessions in exchange for a bigger security deposit or somebody guaranteeing that, if they get these concessions, their business will be fine and they'll be able to pay rent going forward. To your point, I think it was Ann that read the question, prohibiting double dipping. If the tenant receives PPP or EIDL funds, then rent relief would be adjusted. If the tenant can get grants and funds and things, to help pay rent, they should pass that on. Consider confidentiality clauses. If you're having to bend over backward as a landlord to keep one tenant solvent, you may not want all the other tenants to know what you did and then have them asking for the same treatment, if they don't need it. Okay, next slide. So if all else fails, if you don't see any light at the end of the tunnel, and you need to terminate a lease or you want out for whatever reason, here's some strategies on, or some thoughts about terminating a lease. And terminating a lease early and releasing guarantors may be preferable to renegotiating your lease. Every situation is different, but it may very well be that this is preferred versus trying to, resurrect your business and making it in the future. Often is the last resort, but makes sense when there's little hope of a tenant's recovery or the duration of the remaining lease term is short. It's important for a tenant to assess its overarching goals before opting for lease termination. Is this the perfect space that, you're never going to find a better space? It's the perfect thing for your business. You are going to come back and succeed for the long term. That's very different than, you weren't doing that well before and your lease is pretty short and, maybe you could find something better. To this point, the next item is it may be better to cut your losses now and find a new location in 12 to 24 months. Those landlords are going to be competitive. They're going to be offering free rent. As Steve pointed out, they're not going to be as picky about the tenants because it's going to be a tenant's market. Lower rent, improvement allowances, etc., may be coming with that. So again, it's weighing, is it worth trying to make this business work versus if you want to potentially come back and take advantage of a lower, potentially preferable tenancy situations later, So what can you offer a landlord in exchange for termination? A termination fee is a pretty clear example. And while, as a tenant, you may be in bad shape and not have a lot of cash lying around, paying a fee to get out from out from a personal guarantee and out from the lease obligations, that might be a good way to stem your losses and take advantage of opportunities coming up in the future. The other item is furniture, fixtures, and equipment that are already in place. Your liquor license, security deposits can be signed over to landlord. Cleaning the space, organizing it, getting it ready so when landlord takes the keys, it's perfect to start showing to other tenants, and not getting sucked into a bankruptcy, which could delay change of possession and cause a landlord further delays in getting the property back. And as highlighted in yellow here, any lease termination or release of personal guarantee should be in writing and absolutely reviewed by an attorney.
Steve or Roberta, do you have anything to add here that you could recommend with with the exit strategies? Anything we haven't mentioned?
I think that one thing that's worth mentioning is, if a landlord sues for damages, traditionally, and this is in an ideal economic setting, traditionally they get about a year's worth of rent. And that's normally what courts have awarded. We don't know what courts are going to award in a COVID-19 or post-COVID-19 era. So when you're thinking about a termination fee, I think that you can use that as kind of a traditional metric. I'm not suggesting that you are going to offer up 1 year's worth of rent, but I've had a number of clients who have 7 years left and they're wondering, what should I offer that landlord? And I think with a termination fee, you could also do payments over time. And there are ways to structure it where there's some security. If you're not going to be paying rent, I think that it is in the landlord's interest to get that property back, because then they can start to relet it and hopefully start the process of having a broker come in and actually market that.
Roberta, question: when the courts are making those awards, how are legal fees treated, or is that specific to language in the lease?
It's specific to language in the lease, and generally there is a prevailing party attorney's fees provision. So it's not just that you have your damages, And normally courts will say, well, anything above a year and, is speculative. And this is a general rule of thumb. There is no case law that says this. This is just what we've seen in the past. And then attorney's fees are awarded. So what's difficult in a case for damages for non-payment in a lease is that a tenant has to pay for their own attorney's fees, potentially damages for non-payment of rent, and then the landlord's attorney's fees. And I think that making all of the arguments that everyone outlined earlier with respect to how backlogged the courts are going to be, the fact that this is so unknown, I think that you can take all of that into account when looking at a termination fee. I think ideally a termination fee would be anywhere between 3, 4, maybe 6 months. But the other thing is, if you have cash on hand, a lot of landlords are cash strapped right now, and a lot of them need money in hand. So it may be worth your while to say, look, I can come up with X amount, let me out of this lease. And they might just need that money and take it.
Right, thanks. Hey, Alan, would you advance the slide, please? I just kind of want to hand this over to Steve right now. I want to make sure that we can cover his 2 slides. But he's got some really, really great information that I wanted to include here under exit strategy. And I've had this happen to a couple of my clients in a sale. They got into a seller financing deal that was outside of the perimeters of what SBA would allow. So in other words, a seller financing for 2 years, while the buyer looked for an SBA loan to be able to pay the seller back. And you have to do it correctly. So Steve, I'm going to hand this over to you really quickly. And again, I'm willing to stay on. If anybody else needs to jump off at 12:30, I'm willing to stay on and answer the questions. So if we run a little bit over, I just want to put that out there.
Sure. And I think all the participants have our contact information. So, they have my email address. You're more than welcome to contact me. I'd be very happy to discuss things that have covered more in depth, or the stuff that I've got here. I can't really cover in, 2-3 minutes, and I see there's 30 questions. So I'll just be very brief in saying that, SBA has new guidelines now for businesses that have been closed during the shelter. And their basic guideline is that they want to see, a 24 to 30 month operating experience, history before they will finance, unless there's an extenuating circumstance. Like, for example, I'm selling a bar building with a bar and doing a 2-pronged close. We're doing a 504 on the building closing this month, and they're deferring closing the business 7A because bars are closed. And in this particular case, the bar was closed when we got into escrow because they had their license suspended. And so when we got into contract, the business was closed. But anyway, the rationale is for deferring the 7A loan is because they want to have more running room to make sure the bar can open and have a track record to generate some cash to pay the mortgage. So, what this slide is basically saying, that if you've been closed, forget SBA in most cases. So they want to see a 24 to 30 month, and what they're suggesting is to have the seller carry back 80% of the financing at above SBA rates, which is around 5 or 6% now. So there's some justification for SBA to come back in after they've seen some tax returns supporting the income and expense history after the shelter in place has been terminated. So then they can make a determination as to whether or not it's financeable by SBA standards. So it's a lot of conjecture. And again, if you want to discuss it more in depth, please feel free to contact me. And again, in consideration for all these questions, I think that's about it as far as covering this.
Thanks. Alan, forward slide, please. One more. And also we'll include in the deck this great article that Steve wrote for Biz Buy Sell on considerations for taking over a closed restaurant. I was hoping to have him speak on it, but it's a really, really great read. Any short thoughts on this, Steve? Like little nuggets you want to offer?
Yeah, generally speaking, there's a lot in there. So again, I would suggest if you have an interest, look at the article. I was asked by Bob House, the president of Biz Buy Sell, to write this article. And so I would suggest you read it. And then if you have questions or comments, please contact me. You've got my direct phone number and you've got my cell phone, and I'm email. I'm very receptive to, talk about specifics.
Great, thank you. Slide, Alan, please. So we just kind of wanted to end up on future opportunities, but before we wanted to end it on a really positive note, and I want all of the, rather than just reading the slide, maybe each of the panelists to go over maybe a quick point. But before we do that, I was going to launch a poll, but I don't think we have time. I'd just like to see a raise your hand, a show of hands, if any of you would like a follow-up to this particular session, or if you would like or if you would like another session on buying and selling restaurants and more on exit strategies. So I'm seeing a lot of hands go up. Okay, so we're going to organize something for you. We'll do another round of this, and obviously we'll make it a little bit longer and answer your questions. But so for you, Mike, name one thing like in a future opportunity that you can, you'd like to share that you think is going to be significant right now.
Well, specifically in San Francisco, but to the same extent everywhere, there was a lot of value in the assets of existing restaurant operations. Even if they weren't making money, somebody could sell the furniture, fixtures, equipment, the liquor license, et cetera, and this could run hundreds and hundreds of thousands of dollars. So a startup business might come in, and before they got the doors open, they were in the hole $500,000. That, for a modest-sized restaurant. So the future I see is a lot of beautifully built out, fully functioning, both food and beverage spaces plus great retail spaces that landlords are all trying to lease at the same time, and they're competing for tenants, and they're offering these beautiful spaces for low or no key money. Alcohol licenses have already plunged to half of what they were before in San Francisco. They were about 260,000. Last I heard, it was 125,000. Rents are more likely to be better, lower startup costs. You're going to be.
Mike, can we finish up here?
Yep. So there's going to be a lot of great. It will be easier and less expensive to start a retail or food and beverage business in 12 months.
Thanks. Steve?
I'll just tell a cute little story here. I sold this little restaurant in Tiburon, Main Street, Tiburon. It's got a head-on view of San Francisco. It's a small place. It's 1,000 square feet, has a deck that seats about 30. She knows she's going to get killed with the dining provisions and et cetera. So she needed to deal with the next door tenant. They have a huge deck. It's 3 times the size of hers to do a cut-through. And they've gotten approval for ABC to basically, license that area. So she'll have 3 times as much outdoor seating. And so she's ready to basically seat as many people as she could before by having this extensive. People are creative. I mean, I just talked to the director of planning of Corte Madera. They're putting the city plaza into a whole big outdoor seating area to accommodate all the peripheral restaurants around. And there are a lot of communities that are doing these big bulk outdoor seating areas. So there's a lot of positive things that are being done by communities, by individuals to deal with the distancing and all the requirements of, post-COVID. So people are thinking out of the box, and a lot of them are going to continue to be very successful operators.
Great. Thanks for the comments, Steve. Roberta?
I agree with everything Michael and Steve just said. And just to keep it short, I think moving forward, as you move on, hopefully to either expand your business or do another business, we're going to see tenants be in a much better position to negotiate leases, not only in the short term, but I think that this experience has really given people a lot of insights into the way leases should change moving forward. And hopefully that will be a long-term change.
Great. So thank you for your comments, everybody. Alan, if we could advance the slide, please. Okay, I want to just advance it a few more just to show that when everybody receives the slide deck, that they're actually going to get everybody's contact information here. Move it forward, please, Alan. Thank you so much. And then Roberta's. So we can just go ahead and take it to the end there. And I really, really understand that we've gone a little bit over and haven't had a lot of time for questions. Anybody that needs to jump off right now, I completely understand. I'm willing to stay on. Any of the panelists, Mike, are you willing to stay on for questions? Or anybody else? Oh, great, thank you. Great, terrific. And do you want to take us over the finish line? Can you stay, by the way?
Well, I have an obligation now. Yes. All right. So I definitely want to answer some of the questions in here. And one thing, a couple of times it's come up in a few different ways. People are asking, how do they now? And just so that you all know, the SBDC doesn't endorse any particular brokerage or attorney. We so appreciate their help and their assistance here. But given the current climate, how can SBDC clients and participants find an attorney that has time and the ability to look over leases or termination agreements? I mean, are there some suggestions about where to go for someone reputable? Roberta, specifically.
I think you should talk to other business owners and see who they use, see who they're comfortable with. There are a lot of attorneys out there who are willing to be helpful, to give some limited free time, maybe even reduce some of their rates. And I think the best thing that you can do is talk to other people. If you're looking for an attorney, talk to other people that you trust. Talk to your broker, talk to your CPA, talk to other business people to see who they use and what their experiences have been. And I find that when it comes to attorney referrals, I honestly think word of mouth is the best endorsement that you can get.
I agree.
One question that I'd seen was regarding opening up your books, and there's some inherent danger to that. Michael, you had mentioned that as far as negotiating reduction of rent, having your landlord see everything might encourage them to increase your rent later if they look at what it was pre-COVID. How can our retailers and business owners protect themselves in this case?
You know what, one thing I'll add to that, because I had the same conversation with a client last night, and he pointed out, you know, our sales can fluctuate, even pre-COVID, you know, from day to day, they could vary wildly. And if you're negotiating with a landlord or, you know, something is tied to the performance and you have a spike one day, it's not indicative of what your month is necessarily going to look like. So yeah, it probably shouldn't be a direct minute by minute link to the POS system, but maybe rather a sales summary per quarter or per month or something that's more realistic if it is tied to a percentage rent in the lease.
I also think that there's a little bit of a danger. Look, most leases, when you go into an option period, you're going to have it fixed at fair market value or a specific amount. So opening up your books with an increase in rent, and I ask all the great brokers on this panel to tell me if they disagree, but it's only going to open you up to an increase in rent if you don't have something fixed for an option period. So I think that that's something you should examine in your lease to see, if I open up my books and I'm doing really well, what can my landlord do? Not only today, but 5 years from now. You know, if your lease is going to be up in 2 years and it's just up and it's an open book, and landlord could say, if you want to stay, double it. I know what kind of business you do. You may not want to open up those books.
All the years I've known you, Roberta, you've never liked your clients having to open up their books to landlords, ever.
Information is not a good thing. Free information is not.
And many times we've been on opposite sides, and I've seen that. So
with all the transactions I've completed, I've never seen a situation where a landlord has asked a tenant to open up their books. So.
Jennifer is saying, my landlord has many properties. All of them were obtained through an Inheritance, I don't think there's any mortgage. She's very angry that she's not getting rent. Also wanting, she's also not wanting to fix important things in the building. Should I use my SBA loan to pay the back rent? Any recommendations there?
Who wants to take this one?
I can talk about that. I was actually typing a response to that, so I'm ahead a little bit here. I think it really depends on how much you want the space and what personal liability you have if you break the lease. Some landlords are, you can lead a horse to water, but they may not drink. And you may have an unreasonable landlord who, for whatever reason, would rather not, would prefer to have an empty space than be reasonable and negotiate. I mean, your nuclear option is to break the lease and leave them with an empty space. And if you don't have personal liability and you don't really have to or want to be in that space, then the downside is limited for doing that.
What about she'd also asked regarding, in her building, the landlord is refusing to fix the hood ventilation until rent is paid, but it's too hot and unsafe. Any other things that they can do to kind of force their hand? Is there any options there?
Well, I think
I can answer that. Oh, go ahead, Steve.
Hood ventilation is usually the responsibility of the tenant.
Yeah.
So I don't see how they would be imposing upon the landlord to deal with hood ventilation, unless the lease says to the contrary.
What about for clients that find or people who find their landlords immovable? Jesse saying that her landlord or his or her landlord refuses to provide rent relief other than 2 months deferment. Is that when you consider all of the walking away options, or what are your recommendations?
I think that you have to look at a number of things, and I think Michael and Steve have pointed this out. Do you have a personal guarantee? Is the lease with you? Is the lease with an LLC or a corporation? These are all important factors in making decisions moving forward. If you want to stay, I think that every communication that you have with the landlord, whether or not you want to stay, I always tell people, I want you to imagine that a third party is going to see that communication. Put your emails and your letters as though a third party is reviewing what in fact is happening here. And I think it's really important, if you want to stay, to at least make some effort towards paying rent and showing some kind of good faith, and so that you can show that perhaps the landlord did not.
Let's see. Terry.
And there was a.
Oh, sorry. Go ahead.
Oh, there was a question here, anonymous attendee, about. I'd just like to read this. I think it's important that we recognize that a lot of the people who are listening here are, they're doing everything they possibly can to save their businesses, and we've dug into a lot of ways and reasons to terminate. And I'll read this with respect to you all. I think this last part is in bad taste. We're looking to save our businesses, and you're delivering a sales pitch on how people can buy them when we fail. Not the best timing, in my opinion. So I would say to this, hopefully the strategies that we've laid out here will give you an edge in negotiating with the landlord, should you be in the camp that wants to do every possible thing to save that business. There's plenty of people who are looking at the future going, this is not worth saving. And hence the idea of being able to negotiate and limit your liability as much as possible.
And I'd like to chime in on that too, Mike, because it depends, as Mike said, case by case. I just had a meeting with a client yesterday, an SBDC client, and they are losing their lease in 2 months. And they're like, well, there's this opportunity that's come up across the street, our current landlord wants to take over our space and run his business there. We've done such a great job with the catering company. He wants to jump in on it, and so he's not going to renew our lease. We've got 2 months left. This great opportunity has come up right across the street. We could take all of our FF&E and move it over. And our conversation was, well, is it really the time to do that? Like what, I know this space seems convenient, but you're now going to have to go from a bona fide catering company to a new space, a relaunch on, meal prep and delivery for the most part, because catering's not going to come back for a while, and so is it the best choice to actually do that now? Could you provide that landlord across the street with an LOI to maybe rent in January, or to give yourself a little bit of time before you can open up that business? So what we're doing is, we're not trying to do anything reckless here, but every scenario is completely different. And what we're trying to do is to give you as many options as possible that you could take back and apply them to your particular situation.
Oh, and I want to also point out that in many cases, the location and the space is very intrinsic to the business. But it's not always the case. And that concept, should you break a lease, that concept could be reborn in another space, either immediately or in a few months or a year, that could be even better for the business long term.
Okay. Are landlords, do we know, are landlords able to pursue other remedies like tenants are in terms of COVID financing? Louise, have you heard about this?
Yeah, landlords are applying. I just have a landlord that I represent in San Francisco that owns about 50 spaces. And he applied and got both EIDL and PPP. So, when there's a question that came up here, is it okay for the landlord to ask if we've received these funds? My response to that would be, well, why don't you ask the landlord if he's received funds, he or she has received funds? Because, at that point you can start negotiating. And Roberta and I had a conversation about this earlier, that really, for this to actually work, there has to be a lot of communication between you and your landlord, and you both have to open up your books, and you both have to show each other, look, this is my base rent, I've got a mortgage, this is what I've got to cover, I got some PPP for this, what did you get? And together you can kind of piece it together and try to make it work for both sides. I mean, what are your thoughts on this, Roberta? I mean, I think that's,
I think that that's the ideal, right? And the ideal is that people are reasonable and they're coming together and they're trying to make this work. The reality for so many of you out there who are watching this is that you have landlords who are being difficult. I have seen everything from landlords trying to serve 3-day notices on my clients to landlords calling my clients and saying, how can I help? And so, you can do everything possible to try and work with your landlord, and they may not do so. But I think it's worth the effort. I think it's good to have many of these things in writing and to try and be reasonable, especially if they are reaching out as well.
I think that that's a really good point. And this is, they got to be symbiotic, right? I mean, we need our landlords to maintain our properties. We need our landlords to be successful so that we can continue have a place to locate our businesses. So definitely we're talking about this from an advocacy perspective for the small business owners, but we realize that this is it's got to be a two-way street, and being able to document, I think, is a great way to protect yourself later should you need to. Brian is asking, he says has a personal guarantee through 12/21 on his location, on his lease. He says he's not currently behind on rent. What is the legal climate for landlords enforcing guarantees?
Well, I think it goes back to what we talked about earlier. I mean, a landlord can enforce the personal guarantee if the underlying tenant defaults on the lease. So, what's good is that there's a mitigation in terms of the liability. But if there is an unlawful detainer action against the underlying tenant, the landlord can come after Brian personally for damages.
Okay. Some people, Pam was asking, what happens if you don't have a force majeure clause in your lease? Anything people can do there?
I think if you don't have a force majeure clause, I think that's where we start to look at the idea of frustration of purpose and impracticability. And so that's where I think that attorneys and tenants and eventually courts are going to start to look at, what needs to happen. And we don't know what the outcome would be if it went to court, but I think that a tenant does have a good argument to say, I was forced to shut down. I could not operate the business I contracted for, and therefore I cannot pay rent. And I should not be obligated to. Whether or not a court agrees with me on that remains to be seen.
Okay. Somebody had mentioned contacting representatives as far as advocating for yourself, and probably in association with the bill Roberta was speaking to earlier. All of our representatives in the state of California and our representatives on a national level, they all have websites and places where contact information is up front and center. You shouldn't have to look too hard. They also do take phone calls, and I would definitely encourage people to make their voices heard. Eileen was asking what you're seeing to be considered as a fair termination fee. I think she was hopeful for 1 month rent. Roberta, you had said up to potentially 5 or 6 months rent. Could you just talk about the considerations going into what you offer again?
Now, just to be clear, I personally have not seen too many agreed upon termination fees at this juncture. So it really is going to be specific to landlords. As I said, mostly in good times, landlords were able to get damages for about a year's worth of rent and additional rent. Courts found that anything beyond that was speculative. So we can use that as a metric. We don't know if courts are going to make that lower in a COVID-19 world, or if they're going to make it higher. There is a chance. I've spoken with litigators who said, hey, courts say 1 year because they say after a year, you should be able to rent this out. But if we go into a depression, are courts going to use that same metric? So, I know it's a little bit complicated, but I use that 1 year as an example and a touchstone. And I think that you can negotiate and say, look, I will provide you with 1 month of rent plus the deposit and for a termination. And I will leave you with all my furniture, fixtures, and equipment, and we will both walk away without any liability. I think it's like anything else, trying to negotiate what the landlord will take. I actually represent a landlord, and we are doing a termination agreement right now for 4 months worth of rent. And in that instance, he just said, I don't think I'm going to get anything else. I'd like the space. I want to relet it. And these are good guys, and I feel bad for them. He's a good landlord, but he asked for 4. So I think offering what you can and seeing where those conversations go is good. I do think that if it's an amount that you can't pay now and you can enter into an agreement to make payments, even if they come later, getting out of that lease and potentially having that larger amount awarded in damages not hanging over your head would be a positive thing.
Yeah.
I recently sold a business pre-COVID, and the assigner had continued liability in the assignment, and they wanted it to be eliminated. And the landlord and he agreed to 6 months of rent for him to be eliminated for any continued personal liability after the close of escrow.
Anil is saying that they're a quick service restaurant doing takeouts only, and their revenues declined drastically. The landlord had given a 30% reduction plus the triple net for 2 months for April and May, but they're not responding to a request to extend it to June. If I just pay the reduced rent for June and wait for their confirmation, will I be considered delinquent or late? Any suggestions for Anil?
I think that technically you're going to be considered delinquent depending on what where you live in California. However, again, it goes back to you doing paying what you can in good faith and showing that you're making good faith efforts and documenting every time that you've reached out to that landlord. I wrote a letter last week for a client that said, we reached out to you on all of these dates. We left you these voicemails. We sent you these emails. We've had no response. Enclosed, please find the following. If that is the best that you can do, I think that that is a good move for you to make and to show that you're acting in good faith with your landlord. I think it's favorably on that.
Okay. Louise, I'm going to have to wrap up here, and I think a lot of people are falling off. I would just like to wrap some of these questions with one that Eric had put in. He had said there's a lot of great information on how to negotiate or terminate a lease while minimizing personal liability. Do you have any info on the same thing with our SBA loan? Should we find ourselves out of business or unable to get out of our lease? It's another large liability. This is where the SBDC can help you. Any type of business you are, restaurant, retail, attorney, doctor, we are here for you. I definitely recommend that you put a phone call into us and to access consulting or counseling with an advisor that can step you through your personal situation with your cash flow and help you come up with some options that make the most sense for you. We're always available and our services are free. Thank you all so much. Is there any final things you wanted to say, Louise?
No, I think that's good. There were a couple of other questions, and I'm willing to stay on for a while and chat and respond to them in writing or stay on and talk them over with Mike if he's available to stay on. Otherwise, it's fine. Everybody may go to lunch. I can hear your stomachs rumbling from here.
All right. Thanks, guys.
Thank you so much. Thanks,
Thank you.
everybody. We really appreciate you.
Thank you. Bye-bye.
Thank you. Great job.
Louise, I can stay with you for a little bit in case you need any back end support for about another 10 minutes.
Right. Oh, thank you. Great. So there was one, Mike, I think this would be a good one for us. Are there buyers out there in the market now looking to purchase businesses, and what's the current climate? Because I'm seeing a little resurgence right now, a little bubbling up. I think people are starting to look for deals. What are you seeing?
Yeah, I am. There are people out there that are looking. I've spoken with Steve and another agent that works with him. They're putting offers in on spaces for people. I had a bar client contact me, and although he shut down, he said, "Hey, I want to be the first to know if deals come up." So yeah, there's people out there. I've also got another client that's a quick serve restaurant. They're busting at the seams because they're doing as much volume as before. Of course, all takeout, but they're all the apps are generating additional business for them. So they're looking at doing a deal. We're still trying to figure out what they can pay, in terms of or where the value is, post COVID here. But yeah, the answer is yes. There's people out there. I think a really big consideration in selling and your chances of success of finding a buyer is how reasonable is your landlord. Because even if you're giving the place away, if the lease is not reasonable, with the new realities, you're going to find it very difficult, if not impossible, to get somebody to take over that space or that lease.
Right. Okay. Can you do more on exit strategies, how to terminate with the least amount of pain to all parties and avert legal actions when the landlord cannot make changes and the tenant revenues post-COVID are simply insufficient? So Katie, I don't know if you're still on the line, but I want to address that. And I think that Roberta kind of talked about that one a little bit in terms of if it's not going to work, it's not going to work. And it might be in the best interest of the landlord to let you go so they can find a tenant that can step in and actually start paying rent. It goes back to having that discussion with the landlord again and just being brutally honest and saying, look, here are my books. I'm at 0, or I'm at, 20%. We don't know what the future is going to hold. I'm out of money. I'm out of options. Like, let's negotiate, right now on getting me out, because you don't want to have to sue me right now, because the legal landscape is so murky on everything, and again, it goes back to the tenant really having the leverage right now. So again, if you're willing to offer up something, it might make for a little bit of a situation where everybody feels as though they're walking away with something. Maybe the landlord gets some furniture, fixtures, and equipment, or maybe he or she gets a liquor license. And again, being able to do it amicably, and gracefully, that's the key. Do you have any thoughts on that, Mike?
Yeah, I would say that it depends on your situation. If you have personal liability because you've signed a personal guarantee, or you personally signed the lease, or you have a corporate entity on the lease and that same entity owns multiple other locations or other business units, then breaking the lease, this liability is going to follow you. So if you have a situation where this liability is going to follow you and it's significant, I would get a lawyer involved pretty quickly if you're dealing with a landlord that's unwilling to kind of talk through these issues and come up with reasonable solutions that you're happy with, in part because the lawyer may be able to communicate some of the landlord's downside better, but also because the lawyer would be able to go through your lease with a fine-tooth comb, see maybe if certain parts of it could be invalidated, maybe the personal, maybe this frustration of use could come into play. And also ensure that everything you are doing is documented well and that you have the best case possible should you break the lease and get sued by the landlord later.
Yeah, great. Thank you. Jennifer said the hood ventilation is part of my landlord's building and her property to keep repaired. That goes back to that question. In that situation,
Yeah.
I would kind of demand, without the hood, I can't cook. So you've got to fix that hood.
Yeah. And here's another situation where a few $100, for a lawyer to write a letter that points out these clauses in the lease specifically and says, you are in violation of the lease. I cannot operate my business, or something to that effect. Again, that may set you up for success later with regard to winning a case or being in a better place to negotiate.
Right. Question here from Renee. What do you estimate the value of a type 47 and 48 license in the current market? Renee, it all depends on where you are right now. Pre-COVID, Napa licenses, 47s and 48s were 450,000. San Francisco was about 250, 275. They're dropping. The values are dropping right now. We had Carrie Peters on from ABC License Company last week, and she had said that she'd seen declines of upwards of about 50% of the values of the licenses right now. Are you seeing that, Mike?
Yeah. We the last I heard, it went in a month or so in, it was down to 140, down from 260, and then the last I heard it was 125. So yeah, that's 50% or slightly more in San Francisco County.
Right. Okay. What are the penalties still being economically solvent and for stopping and paying your lease with a desire to leave the lease without having an agreement from your landlord to do so? Well, I think if you're just talking about handing the keys back, I think you are opening yourself up for liability. Again, we go back to having that communication with them and trying to work out a strategy for both of you, given your current situation. Will be interesting to know more information about your lease, how much time is left, do you have a personal guarantee, that sort of thing. Mike, to what extent is it fair for the landlord to expect to be paid back in full in light of the lessee receiving EIDL and PPP funds? I
think it's a calculus that the landlord's going to have to go through. I don't know what the economics of those funds are with respect to the cash flow of your business. You know, and if you're getting a lot of funds and, you know, if you're flush with cash, then you're in a better position to you know, pay your obligations to the landlord. I think it's just going to be case by case basis, and there's no definitive what's fair and what's not. It's so case by case.
Yeah, and I think for, you know, I mean, idle, you know, depending on what you receive, that was preliminary set up for you to get 6 months of operating expenses. You know, but the PPP is set up a little bit differently. So depending on what you got and how much you got, I mean, you know, that was to help you, especially idle, was to help you with your rent payments, you know, over a 6-month period. So unfortunately, a lot of people didn't put in the right amounts in the box because it just asked for your COGS and not your operational expenses. So a lot of people ended up getting a lot less, but you know, it's definitely can also be used as a negotiation tool to help you to negotiate something longer term down the road. So again, like Mike said, it's a little bit case by case. Well, it's 1 o'clock and we answered 48 questions.
Wow.
We have 15 left. Everybody will be getting the deck, which will have our contact information. So feel free to email us if you have a burning question. We're happy to answer that for you. And thanks for staying on. I know there's still 57 of you out there. We really appreciate it. And we're here to answer your questions. We're here to help you in any way that we possibly can. So with that, I will end it. And thank you, Zoom God, for
Thanks, Alan.
For managing us and
Managing you. That's always a challenge, Louise, but it's a pleasure to do.
You're welcome. Sean, I didn't do the webinar on Tuesday, so I don't run that one. So as soon as Alan has the recording, I will send out an email to everybody with the recording and the link to the deck. So I can't answer to what other instructors do.
And Sean, I can tell you that you'll be getting something this afternoon. I mean, we've been holding back to try and get the rest of the information. So you'll be getting something. I literally got the go-ahead to send something out as this webinar was starting. So I'll be on that one shortly.
Oh, that's the cash flow. That's Paul's one. Okay, got it. Okay, goodbye, everybody. Thank you so much.
Thanks, Louise. Thanks, Alan.
Thanks, Mike. Thanks.